going to take a couple minutes for Walt Boyer to set up his. He did speak a little bit about his committee's work as they have researched model laws and legislation in conjunction with the Financial Soundness Task Force. And I asked him to present to you all an in-depth report to you this morning. He and his committee have performed yeoman service, and it continues. And at the conclusion of this presentation, Walt will also be available to answer a few questions. We are kind of, we pay at least an hour for you, Walt, so we got that coming up. So if you want to set up. Okay, and here's Walt Boyer, you have all met. He is chairman of our committee. He also is president of the North Carolina Association. He past president of or chairman of the Deerfield Residents Association. Also, he's retired Navy, so go Navy, and so, except we'll say also go Army. Okay, there you go.
What about the Coast Guard?
As a matter of fact, the secretary of the Western region in North Carolina is a retired Coast Guard, so and lives at Deerfield with us. So we have just about everything. We've had generals from the Army, 4-star generals from the Army, 3-star generals from the Air Force. I think we may have a 4-star from the Air Force coming in, and a couple of admirals. So we do pretty well in keeping across all of the services, including one of my closest friends in the Navy has introduced me to the former vice chief of the medical service, Uniform Medical Service, and he's a great man that we much admire. Ruth has asked me to give you an update on the model laws and the Financial Soundness Committee that the Financial Soundness Committee has developed. And in large measure, this is a repeat of the presentation I gave last year. So after this great presentation by Jack Cummington, I think he did a marvelous job. I don't think anyone can maintain the pace that Jack maintained at the last presentation. So if you've seen this before, you were at the Estates at Carpenters last year, you have permission to fall asleep, so long as you don't snore. Make sure I know how this works now. That's good. I wanted to list a few of the issues that we heard and have been hearing that drive the initiation of our Financial Soundness Committee. There are quite a few of these, but I thought I'd put a few up. Leading Age recently reported that there are now 1,902 not-for-profit CCRCs in the United States. I try to keep a tally on my computer of those that have had trouble, and I know it's incomplete, but I would estimate that about 1% of those CCRCs passed through bankruptcy or receiver during the recent recession. And many more were clearly in financial difficulty. Quite a few of those got bought out by others to save them. A couple of years ago, a Wall Street Journal report suggested that the rate of commercial debt infractions with CCRCs exceeded 3%. Residents have been expressing concerns about fiscal transactions that they believe were not in the best interest of themselves. A number of states believed to have strong laws protecting resident interests can be counted on your fingers. Resident contracts have been seen, and Jack Cumming can give you a personal count on this, that managers could change their contracts arbitrarily at any time to suit their needs. And the resident had no say about that. The fiscal oversight provided by many states, despite laws and regulations, is reported to be all but non-existent. They have the laws, but they don't have the people to enforce them. The frequency of resident cries may have subsided a little bit in the last few years when we were in this recession, but I think those issues remain, and you have expressed a number of them in your comments during this meeting. We established 4 goals for the Financial Soundness Committee, which I show you here. The committee has pursued the first 2 very strongly. We've essentially ignored the 3rd one, and I'll tell you why in a minute. Federal accounting, instead of addressing the Federal Accounting Standard Board's standards, we've gone to a more fundamental level, and this was suggested again by Jack Cumming, addressing the subject through a medium of standards and model laws and statutes that we would like to see adopted by the several states and the federal government. Committee is also considering, or also considered for a while, including a resident Bill of Rights within the purview of this committee. However, because of its importance, it's been separated out into a separate committee by Dan Seeger. When we took a look at this, Jack Cumming, I have to tell you, he is a great guy, as far as I'm concerned. We're very grateful to Jack for the initial preparation of these 14.
What was that term there, Walt?
Pardon?
What was the term for me? I'm just curious.
He's a great guy, I said.
Oh, great guy. Oh.
Yes.
I thought you said he's a freak out.
Don't misquote me. Anyway, Jack took it upon himself to initiate the preparation of 14 of our model laws. Many of us, including myself, when we moved to a CCRC, looked at it as a form of insurance. And it takes just one more step to suggest that the laws and regulations governing CCRCs ought to model upon those governing the insurance industry. Jack's background as an actuary in the insurance industry was critical, I think, to the preparation of many of the laws that we are proposing. And the fact that he is a fellow of the American Society of Actuaries helped a lot too. Last year we reviewed these laws internally, and as a result we made a few minor changes, but we also added a 15th law. And we call these our CCRC standards and model laws. Jack told you yesterday how you can find these on the NaCCRA University website. Last October, they were passed to the National Association of Insurance Commissioners Senior Issues B Task Force. We did not expect any prompt action on them there, primarily because we felt that body was heavily involved with the Affordable Care Act. And Jack went through that act for us just a few minutes ago. I think all of us know the history of that act and can understand why the insurance industry and the insurance commissioners were heavily involved in worrying about that and how it was going to be implemented. Nonetheless, the next 4 slides, I'm going to go through the 15 model laws which we are proposing and which we hope, upon which we hope we can get some action by the NAIC this year. I have grouped these laws in my slides as they relate to some of the basic concepts of residence rights. The resident contracts, for example, vary widely among our CCRCs. Some are well balanced. They describe the rights afforded to residents clearly and to the providing also clearly. Others have been so one-sided that it is questionable that any reasonable person would accept them. Many lay somewhere in between these two extremes. The public is entitled to be able to understand the commitments which they undertake, to ensure that there is mutuality in agreements, and that the contracts provide a full meeting of the minds between the resident and a provider. The model CCRC Standard Contract Provisions Law calls for these contracts to be written in understandable, clear, and unambiguous plain language that fairly balances the interests of residents with those of the business entities that offer the contracts. Most individuals entering in a relationship with the CCRC fully intend to spend the rest of their lives there. The requirement to expend a significant portion of their life savings in that commitment seems a reasonable risk to them. However, for the few that find that they have made a mistake in opting for the CCRC lifetime, or later have a good reason to find a need to change the class of unit occupied, costs of change under many existing contracts can easily result in an additional and to many eyes unfair drain on their life savings. A couple examples. A few years ago we had an individual come to Deerfield who, after about a year and a half, decided that was not for him and his wife, and he wanted to leave and move. And I felt myself that Deerfield was rather generous in the way they handled that situation. But I have heard of other CCRCs in which a person who in that position has to leave and essentially their entry fee has been lost. That's the kind of thing we don't like to have. Another situation is an individual who comes in, perhaps lives in a cottage initially, and then finds later on that they need to move to an apartment to be closer to the community center and to the facilities that are in that community center. And in that case, some CCRCs will allow an allowance for what they originally paid, but charge them for the new cost of a new entry fee for the apartment. And I think those kind of things are somewhat unfair. This law, the model non-forfeiture and transfer laws, are designed to allow the execution of these kinds of changes in a more fiscally fair and balanced manner. There is a growing popularity among senior housing facilities for cooperative ownership that is being seen to extend into the CCRC community. These are things like our retirement facilities in which residents are allowed to own their own residence or may have a fiscal or financial interest in the community itself. Several industry authorities have declared it to be one of the important waves of the future. Many believe it to be an important attraction for potential residents. And I myself might have been attracted to one like that if they'd been available to me. The model CCRC Cooperative Conversion Law provides some standards for CCRCs desiring to enter into this type of ownership. The CCRC Governance Act states that residents cannot be excluded from boards of directors simply because they are residents. Neither does it require that boards to include residents among their members. What it does say is to recognize that a CCRC resident retired from years of occupation in a particular field may well have a broader experience, background, and expertise in that field than someone in the community in the middle of their career. And it requires search committees to take that experience into consideration and provide them with a level of precedence when offering candidates for board positions. The model CCRC prepaid medical insurance law recognizes that many CCRCs annually provide residents with a statement telling them that a certain portion of their entry fee and monthly fees are tax deductible as a medical expense under US IRS Code Section 213. How many of you have received a letter from your CCRC that tells you you have a tax deduction? Yes, quite a few of us get them. This model law calls for these amounts to be accounted for as a liability on their books, termed prepaid medical expense in their CCRC accounts, and that these monies should be invested for use by the resident or medical expenses in the future. The model CCRC Investment Act limits the types of investments in which CCRCs may invest its funds. Like many other of the model laws in this series, it is based upon and closely parallels similar laws governing the activity in the insurance industry. Now, it's my personal belief on reading what Jack wrote in here and what's in the insurance industry provisions, that many CCRC CFOs would find his provisions extremely liberal. I certainly did. And I think that it is useful, however, to place some reasonable limitations on the CCRC investment activity. One of the things we have been looking at is CCRCs that have been in trouble, and one in Oregon recently had an owner who wanted to invest some of the reserves in a facility down in Mexico. It eventually failed. And in a golf course, that was a public golf course, and some of those kinds of things we think are inappropriate. A few states are now authorizing CCRCs to expand their offerings to include provisions for continuing care at home. The model CCH authorization law limits the scope of such activity to 25% of its revenue for similar services to residents. It makes such activity above that subject to the same laws and regulations governing long-term care insurance contracts in the state. The CCRC Financial Guarantee Act establishes a continuing care guarantee association in the state and directs all CCRCs and CC at home providers to join it. The association's purpose is to enable each member provider to have insolvency insurance against losses arising from the failure of an insolvent provider to discharge its obligation under its continuing care contract. What this essentially does is provide a bridge, if you will. Right now, under laws in most states, I won't say all states, but most states, if a CCRC goes bankrupt, the resident contracts are at the bottom of the list in terms of recovery during the bankruptcy. And this law would provide for an association which would cover those contracts and provide a means for those contracts to be fulfilled even if the CCRC goes bankrupt. The model law provides for management, operations, assessments, funding authority to issue notes, bonds, debentures, and so on, standing to appear before courts of law in the state, and other authorities necessary to carry out those functions which has been assigned by the association. And we feel this additional protection for residents is very important. The model CCRC financial responsibility law codifies a provision that exists in many CCRC continuing care contracts today for residents to have and maintain adequate financial resources to maintain their financial responsibilities under the contract. It's basically something that you find in most of your contracts today, and we're simply codifying that issue. Model CCRC standard evaluation law calls for an annual evaluation of CCRC reserves as being sufficient to ensure the long-term multi-year commitments under its contracts. Standards for these calculations are provided in the law with provision for substitution of mathematically equivalent determinations or other acceptable alternative methods for determining a CCRC's ability to meet its current and future commitments. The principles involved are the same in law as those applying to comparable transactions and life annuities and life insurance. A few CCRCs in the country go to the trouble of hiring an actuary to come in on a regular basis to look at their books and project what they need and help them establish what their rates are going to be for the next year. Not all do that. In fact, I do not have a good figure for this, but I believe that it's a relatively small fraction of the total. A number of CCRCs try to do this on their own, but actuarial calculations are complex. Jack can tell you that he's an expert in that field. And I feel that we need some way of ensuring that on a periodic basis, every CCRC does take a look at its future, what it needs to meet its future commitments. The model CCRC financial liability law defines several situations under which a state regulator may appear to the state courts to assume possession of the CCRC, take its books, accounts, property, or other assets, and proceed to act as a conservator of the organization. The listed situations include regulatory non-compliance, refusal to properly submit its books, papers, and accounts for inspection, embezzlement, proper or hazardous transactions of business, and certain other activities. Many CCRCs are known to be well run, and they adhere to high standards of care and attention to those provided under their care. I think every person I've met who lives in a CCRC believes it's the one it's in is the best. And I suspect we all have that feeling. The model SelfCertification Act at the state level and the model Aging Services Trusted Providers Act at the federal level provide the opportunity for such CCRCs to earn the privilege of self-certification and meeting the standards required by law and regulation. These acts require a minimum of 5 years of performance with a minimum number of minor infractions to gain this trusted status. Once the trusted status has been gained and approved, the CCRCs may use certified agents of their own choosing to conduct the necessary inspections and certify compliance with the regulations. The model federal end-of-life law amends the Social Security Act to permit individuals diagnosed with incurable disease medically expected to progress towards decline and death to elect to forego life-prolonging treatments and receive palliative care. That is, to be allowed to die comfortably and without pain. Such care shall be known as end-of-life care and is to be separate and distinct from, but not preclude, hospice care. The Act provides that a death resulting from such action by a doctor may not be treated as homicide. These laws are available to you on the NaCCRA website. They have been forwarded to the National Association of Insurance Commissioners for their consideration. We hope that this year we can get them to move on it. We recognize that the model laws will impact only a small portion of the overall body of CCRC governance and responsibility. Each of our committee members has thoughts about what additional areas needing addressed, and this conference and meeting that you had the last 2 days, you as participants have expressed a large number of them yourself. We hope that the committee will be able to take those into consideration and perhaps establish new standards and model laws to accommodate them. We also learn from the experience of others. Two of our committee have been closely monitoring the experiences of two quite different episodes to see what lessons can be learned. Following the bankruptcy proceedings of the Glebe in the Shenandoah Valley, Virginia, Ron Herring participated in a Virginia State Senate study of CCRC issues. In Oregon, the Rogue Valley Manor residents sued the CCRC owners and, through arbitration, received remarkable changes in management and governance. Gerald Highland closely monitored this activity for us. The V at Palo Alto is a new case that's receiving national press recognition. The residents are suing the CCRC and its parent entity in a federal district court. Gerald Highland and Jack Cumming are monitoring the suit's progress, and copies of the court's documents are being made available to the public on the NaCCRA University website. The National Association of Insurance Commissioners is a body that proposes many, and I believe most, of the insurance laws enacted by the several states. This last year, they have been coping with the intricacies of the Cooperative Care Act and the responses of the states to that national legislation. We have hopes that in this coming year, that preoccupation may wane, and we may have an opportunity to interact with them or their staffs on our model laws. I know that a member of the staff in my state is very interested in one of the model laws, and I will be in communication with them about that. I think that I'm not sure that we can find all of the answers in legislative actions. I personally like a model that is started by the Institute of Electrical and Electronic Engineers. They set up standards for electrical practice and safety that apply now in all the states of the Union. And safety provisions in this building and in your homes before you came here were predicated on the standards which that organization established. I sometimes wonder if it would be possible for NaCCRA to develop standards for the CCRC industry in a like manner that would receive similar acceptance by the states and the authority across the nation. Recognize the needs and aspirations of both residents and providers totally in a coherent whole. And with a proposal. Harry Groves, which many of you know as an early member of NaCCRA and one of the drivers of NaCCRA. In 1988, he drafted the legislation that is now the principal North Carolina statute governing the operations of CCRs in that state. The CEO of Leading Edge North Carolina told me that earlier last week that he felt the laws in North Carolina were the strongest in the country. Other states may disagree, but I will say that we do have very strong laws in North Carolina. Harry went to laws in as many states as he could find that he felt had strong laws, and he took the best of those and put into the statutes that are North Carolina laws today. We know our model laws and the resident rights, which are subject to a different committee being reported on at this meeting. We have a few elements of a set of comprehensive standards for the management and government of CCRCs. Jack Cumming has accumulated much of the related, more important state legislation on laws on the NaCCRA website. I think we should be using this information to glean what we think would be in the best interest of a comprehensive set of standards and laws, standards for state laws in the future. This is an ambitious program. It's really the task you originally gave to this committee. We have come to realize that it may take several groups of committees working in parallel to carry it forward. But I leave you with this question. At this moment, in this meeting, you've seen the tip of the iceberg. We've talked about resident rights. We've talked about model laws. There are only a few, very few, of the whole picture that relates to CCRCs. My question for you is, can NaCCRA take on that whole body and establish the kind of standards that we would like to see? I want to close on a personal note. 6 months ago, I took on the job as president of the North Carolina Continuing Care Residents Association. About the same time, I suddenly started becoming a caregiver. And that function has increased rather rapidly to the point that today I am very close to being a full-time caregiver at home. Because of that, I feel that I have not been carrying out my responsibilities as the chairman of this committee at all effectively. And for that reason, I've tendered my resignation to Ruth and to Dan as chair of this committee. I want to thank everyone that's been involved for all the work that they've done. And I want to apologize for the fact that I haven't been able to do the job I thought I should be doing during the last 6 months. But I do want to thank you for your time and for your patience with me. And I'll ask if there are any questions at this time. We have some lights.
Do I understand that all 15 of the model laws have been enacted in the state of North Carolina?
Not all of them have been enacted in the state of North Carolina. There are at least 2, maybe 3 that have not, and there is some interest in promoting those in North Carolina. Yes,
How many have?
Pardon?
Some of them have.
Some of them are there, yes. Some of them are there in North Carolina. Most of them are there in North Carolina.
Walt, is the intent that they be applicable to both profit and non-profit CCRCs?
That's a good question. And there is an issue there. Some of these laws might have to be modified slightly for a CCRC that was an investor-owned. But basically what we are trying to do is place all CCRCs under the same kinds of rules and regulations that apply to the insurance industry. And as you know, the insurance industry is privately owned in most cases, or investor-owned. There are a few insurance companies. I know Mass Mutual, I think, is one that's owned by the people that have their insurance with them. But I think most are, you could correct me if I'm wrong, Jack. I think most are privately owned.
The model laws would apply equally, although the idea of resident ownership would not be possible in a nonprofit context because of the confusing ownership of a nonprofit. Nonprofits are basically, the ownership is exercised by the executives. So, and they may not have skin in the game, so that's a question. But there are a few nonprofit insurance companies. Blue Cross in California, for example, was a nonprofit and converted to be for-profit. To do that, you have to get permission from the Attorney General, and that's a process that is best discussed privately because of the way you bring it about. But it does involve campaign contributions to the elected official whose approval you need.
Same question as the last question. Does what was presented by you apply to type A, B, and C communities, or only A's?
No, basically it applies to all types of communities and contracts, yes. There may be some minor wording differences. The fundamentals apply across the board, in the back then.
I was interested in what I would call a relatively soft formulation of the model law about governance. In the Delaware Valley, where I come from, where a lot of CCRCs exist, it's often the case that in their early days, maybe about 30 years ago, the governance of the CCRC was actually in the hands of what you might call resident founders. And gradually the boards evolved away from residents to be wholly non-residents. And since residents, in the case of a not-for-profit CCRC, are the sole source of the money that runs the place, I'm wondering why there should not be resident board members who are elected by residents, rather than, as you described, nominated by the board from among residents on the basis of professional qualifications. Shouldn't there be at least some residents or some board members who are deliberately elected to represent residents' interests?
That's a good question, and from my perspective, I think several of you may have different views, but from my perspective, I've seen a variety of different mechanisms for the establishment of a nomination of personnel to boards. Some boards are run very democratically, that the members of the board are elected by constituents that which the board is responsible. In many companies, for example, a board members of the board are elected by the people that own the stock in the company. However, in a lot of those cases, the stockholder really doesn't know the individuals that are nominated very well, and it's to some extent, these are people that are pre-selected, and it's a pro forma type of operation. In other boards that I've been associated with, the nominating committee is given considerable license to look for people who are have specific qualifications that are useful to the board and useful to the organization which it governs. And I must admit, from my personal experience, I've found if you develop a board that has a broad spectrum of expertise in the disciplines and areas in which the organization works, those boards tend to be more effective in general. But I know many of you have been involved with boards of your own, and you may differ from me from my opinion.
I'd just like to amplify that. I agree thoroughly with what you're saying of the need for diversity on the board. But in terms of a resident from the CCRC, that is a particular perspective that is important to the CCRC and does not come from this diversity that you're talking about. So that the idea of an elected member who is a resident of the CCRC has a very specific, separate role to play, and I'm disappointed that that isn't reflected in the statement that you have on governance.
Let me go to Jack.
Yeah, I'd just like to defend this a little bit, because I may have had something to do with this first. So maybe I better.
Gee, you're such a nice guy otherwise.
Well, that's easy for you to say.
A board is a creature of law, defined by law. Under the common law,
Use the mic.
okay, under the common law, the board has certain prescribed duties. The loyalty must be to the enterprise. A board is not a representative body. I think we see in the Congress of the United States what's happened sometimes if you get into a representative kind of context. A board has a duty of care, to be diligent in ensuring that the enterprise is managed on a fiscally sound and responsible basis, a duty of loyalty to the institution as a whole, and not to anybody who may have elected them, represent them. It's not representative. The duty of loyalty is to the institution as a whole. So if residents were to represent solely resident interests to the exclusion of the whole, they would have personal liability, could be sued and held accountable for that dereliction of their duty. The board has a duty of obedience to the collective decisions of the board. It's expected to be a collegial, deliberative body. It's not a divisive partisan body. By law, it's required to be deliberative and to address the overall interests. And it has a duty of confidentiality to keep confidential matters confined within the boardroom. And those responsibilities are quite different in a body like the Congress of the United States, which is intended to be a representative body. And I suppose you could supersede the common law by statute, but the common law practice for corporate enterprises has worked rather well and has served the public interest quite well. I might add that the sanctions for excluding, I mean, there are some executives and there are some CCRCs, unfortunately, which are tolerated by the industry. And that's what's unfortunate. The industry has not policed its own kind, who exploit the people in their care and who discriminate against those people solely because they were unwise enough to accept residency. This law includes a very strong sanction. Under insurance, when the management proves incapable of governing the organization, the insurance commissioner can take over the governance, run the enterprise, usually they bring in a special master or an expert, until such time as the governance is corrected. This provides the same thing, that if it's found by the regulator that the provider is discriminating against residents, which is what is now the case frequently. They will say residents can't be trusted to vote for increases, but executives can be trusted to vote for compensation increases, which is a curious distinction which shows who exercises the ownership. In that case, then, they would be put under notice to correct the deficiency in their governance, and if they don't do so in a reasonable time, then they would forfeit the right to govern themselves until such time as they corrected the deficiency in the governance. I think that's a reasonable approach. But to undermine the whole basis of corporate law in the United States, to make it something like where a Woolworth store, to take an example which is historic, would be governed by so many of the customers could vote for X number of the board members, would be a little bit silly.
Can I respond to part of what you're saying? Part of what you're saying is the same argument that we're getting from management, that there is a conflict of interest of having a resident on the board.
Well, they have a conflict of interest too.
Let me stop by saying, which is baloney.
Well, I agree.
The resident certainly has an interest in the well-being of the community, and if it is required to increase resident costs, that has to be something that they vote for. So I just don't buy that at all, and I don't think most of the residents do.
Well, I think you think you're arguing with me and you're really agreeing, so.
Before we go to that question,
Let me
get
have
some
a
personal
follow-up.
views.
Well, in order to have a coherent conversation, let's follow up on this particular issue. I agree with our friend in front.
Okay.
Let me just say a few things in response to Jack. On the one hand, there's the theory of law. I mean, laws say corporations are people. I mean, there are a lot of theories in law which really don't hold water. So I'm not sure that the argument from law is persuasive. What I'm dealing with is experience. And the experience is that if you have a board of directors of a CCRC, some of whom are lawyers, some of whom are accountants, some of whom are health professionals, all of whom come from off campus, from the surrounding communities, none of whom are residents, they get all their information via information provided by the management, which has no skin in the game. There are no residents in the thing. They just simply are not qualified to understand the situation as perceived by residents. And the second thing is what my friend has said in the front. I mean, it's true the board has a responsibility to the well-being of the enterprise, but in a not-for-profit CCRC, where the whole enterprise is supported by the fees of residents, there is simply a congruence between the well-being of the residents and the well-being of the corporation. So I don't think there's this schizophrenia that people seem to feel there exists. So I don't really see any reason why a governing board of a CCRC, at least a not-for-profit CCRC, why it should not include at least some residents who are elected solely to represent residents. It just doesn't make logic to me.
But our bylaw does not exclude residents from a board. It just says it does not mandate it. And I'd like to explain a little bit about my personal experiences. I've been on boards of 2 CCRCs. The first one I was on, we had a rule that you could not be on a board if you were a resident. And I went so far as to say that if a board member entered the CCRC, that was an automatic resignation from the board. However, a number of those members of the board did have relatives, parents primarily, who were resident in the CCRC. So they did have an interest for the residents. When I went to the second one, the second CCRC, the one where I'm at now, essentially the same situation existed. There were no residents on the board, and boards were not, residents were not essentially excluded from the board for the reasons you have suggested. I happened to look up the law at that time and found that the IRS regulations state that the conflict of interest only applies if an individual is running a business and that business has a contract with the CCRC. That's the only case, the only situation in which a conflict of interest exists under law. It's not even under law, it's under regulation from the IRS. I had some discussions with our CEO about it. Eventually, over time, the president of our residents association was given a non-voting seat position on the board. This was eventually changed after a couple of years to a voting position on the board. And more recently, the nominating committee of the board has agreed that there will be one resident on the board. That resident is usually, the name of that resident is usually nominated to the nominating committee by I will say, conversation that goes on between residents and the CEO. And I've been a party to those conversations. Marlene has been a party to those conversations. We've both been on that board. The conversations look for someone who has a stature in the community and is also someone who is far-thinking, the kind of a person that will look at the big picture and not necessarily want to immediately represent the residents. That resident representation responsibility lies with our Residents Association president and his position on the board. And that's where we stand today. So we've been able to get there. We did it through negotiation, essentially. John.
A little bit of John Knox history, and it's going to be sort of, I don't think this is as black and white as suggested. It happens for the last 40 years. The residents of John Knox Village, or a committee of the Residents Council, submits 3 names to the board of directors. We're standalone, not-for-profit. And their nominating committee interviews all 2 or 3 people usually and selects one. So we have 3 residents on a 15-member board of directors. They serve 3-year terms, so they rotate off. However, they are full voting members of the board. However, and this is where I'm agreeing with John, he is correct, or excuse me, these 2 gentlemen, they bring a special expertise because they're residents of John Knox Village. They're more sensitive to what the residents prefer, don't prefer, etc. I happen to think the model law should mandate that there should be either a number or a percentage of board members on the board. However, they have a fiduciary relationship like any other board member. And if something comes up which benefits John Knox Village, even if the residents don't like it, that resident board member has to think about the best thing for John Knox Village, which takes into account the residents, but not sole discretion. So they've got to recognize there is a legal fiduciary relationship. So they can't just represent the residents, but they do bring a special expertise, which is why I think the law, as we've written it, should say there should be a resident, at least one or some number percentage of residents on a board of directors.
Okay. I think we've heard you. We may want to change that model law.
I've served 6 years on Seabury's board. There are 2 resident directors on that board. The way they get there, it starts with the nominating committee that's part of the Residents' Council. The nominating committee makes its recommendation to the council. The membership of the council, the community, then votes. Then they make their recommendation to the Church Home of Hartford general membership. And they are the ones that vote the resident director to the board. During those 6 years, sure, I was there to represent the residents' point of view on various issues. But at the end of the day, as a board member, I was responsible to the Church Home of Hartford. And I was sworn to confidentiality on what went on the board. So that's the way it works. It works very well, and I agree with John and Jack Cumming. They've expressed it excellently, and I think it works very well that way.
Thank you very much. Thank you.
And I just need to reiterate how much we appreciate all that Walt has done with and for the committee.